So we just left off, right, with the Section 2, how the Section 2 is being used in Kentucky's history. So we're still talking about the Constitution. I just finished that the Kentucky Supreme Court had ruled that Section 3 of the Bill of Rights, which declares in part that all men, when they form a social compact, are equal, together with Sections 1, 2, and 59, embraces the Equal Protection Clause of the 14th Amendment in the U.S. Constitution and might provide greater protection of individual liberties than the federal equivalents. So Sections 1, 2, and 59. So Section 59 says this. Local and special legislation. The General Assembly shall not pass local or special acts concerning any of the following subjects or for any of the following purposes. Namely, first, to regulate the jurisdiction or the practice or the circuits of the courts of justice or the rights, powers, duties, or compensation of the officers thereof, but the practice in circuit courts in continuous session may be by a general law be made different from the practice of circuit courts held in term. Second, to regulate the summoning and paneling or compensation of grand or petite jurors. So you can't be paying grand jurors. They shall not pass local or special acts concerning any of the following. So they can't regulate, summon, and panel or compensate grand or petite jurors, to provide for changes of venue in civil or criminal causes, to regulate the punishment. I don't know what the fuck Section 59 actually is saying, because it's sitting there, it's got 17, 16, 18, 19, 20, 24, 29 fucking things I guess they're not allowed to do, or they are allowed to do. To locate or change a county seat, to provide a means of taking the sense of the people of any city, town, district, precinct, alter the liquor laws, to create, increase, or decrease fees, percentages, allowances to public officers, to extend the time for the collection thereof, or to authorize officers to appoint deputies, to regulate the rate of interest. What the fuck is this? They're sitting there saying that the General Assembly can't pass any of these laws to do any of these things. Like, why not? Why can't they pass laws to authorize the opening, altering, maintaining, or vacating of roads, highways, streets, alleys, town plats, cemeteries, graveyards, or public grounds not owned by the Commonwealth? So they can't do anything that they don't, of land they don't that they own. But why does that even need to be written down? That's 16 of 30 things listed in Section 59. Section 59 pisses me the fuck off. It says that the Equal Protection Clause comes out of the 59, so maybe that's all that they're saying, is to treat others as you want to be treated yourself. To change the law of descent, distribution, or succession. To authorize the adoption or legitimation. To authorize the adoption or legitimation of children. So they can't make children legitimate, and they can't have any children being adopted. The General Assembly can't touch that. They can't do shit about that. To regulate the limitation of criminal or civil causes to affect the estate. Section 59 is pissing me off. Okay, I'm gonna put it down. Section. I don't know what the fuck 59 is all about, and I kind of don't want to know. Okay. So the Kentucky Supreme Court, it says the sections 1, 2, and 59 embraces Equal Protection Clause of the 14th Amendment of the U.S. Constitution and might provide greater protection of individual liberties than the federal equivalent. The Kentucky Supreme Court has generally embraced a generous view of Section 8's guarantee of freedom of speech and press. For example, see Ashland Publishing Company v. Asbury, 612 SW2D 749 1980, but lately has taken a less libertarian view of freedom from illegal search and seizure, duplicating somewhat the recent trend of the U.S. Supreme Court. See, for example, Estep v. Commonwealth, 1983. The Kentucky Supreme Court also has not enlarged the freedom from self-incrimination beyond that guaranteed by the U.S. Constitution. So some of them are just redundant. Resembling the federal Bill of Rights, Kentucky's Bill of Rights prohibits double jeopardy, Section 13, guarantees the right to bail and habeas corpus, Section 16, restricts imprisonment for debt, Section 18, of course, that's the famous Section 18, nobody can be imprisoned for debt. Section 16, habeas corpus, motherfuckers. If you don't know shit about habeas corpus, it's because you don't know the Bill of Rights of Kentucky. Standing armies, Section 22, guarantees free immigration, Section 24, and the right to trial by jury, Section 7. So it guarantees free immigration. You can get the fuck out of Dodge. You can leave Kentucky whenever you want, Section 24. No standing armies at all. No standing armies. So that's Section 22. and the right to trial by jury. That's Section 7. It prohibits ex post facto laws and laws that impair the obligation of contracts. So you can't pass any laws after the fact, and especially after the fact of a contract. Section 19 says the sanctity of a contract just goes on till, to the fucking end. The Kentucky Supreme Court has upheld the amendment to Section 19 that prohibits strip mining under the broad form deed unless such mining is specifically agreed to. Very specific. It's kind of anti-coal, but very much pro-coal, since they're still allowed to strip mine, but they just have to have specific permission in order to do it. And the Kentucky Court of Appeals ruled that Section 4, which is revolutionary section, it gives the Kentucky people the right to violently overthrow the government. They're allowed to do really anything they want to the politicians who do not serve them and give them the peace, safety, happiness, and protection of property which they all deserve. So if you are not happy, if you are not safe, if you do not have peace, if your property is not being protected, then Kentucky's government is not serving you, and you have a right to abolish or alter it as you may deem proper. That's Section 4. That comes straight out of Kentucky's Constitution. So you got a right to revolution in Kentucky's Constitution. So that expands some rights right there too, right? So it authorized the legislature to establish in 1964 the Constitutional Revision Assembly that drafted the voter-rejected Constitution of 1966. So the Kentucky Court of Appeals said that the Section 4, because you have a right to violent revolution, then of course you have a right to authorize the legislature to establish in 64 the Constitutional Revision Assembly, and then draw up a Constitution of 1966 and then put it by statute or by ballot. So the voter rejected Constitution, that's not an amendment. I guess they just put the Constitution up there. They had a constitutional convention, not called a constitutional convention, but they had one, but it was rejected by the voters, which is unfortunate, especially since, well, I mean, why not try it again, put it to the voters again. Section 14 of the Bill of Rights states that all courts shall be open and every person for injury done him in his lands, goods, person, or reputation shall have remedy by due course of law and right and justice administered without sale, denial, or delay. So this is amazing. I mean, I feel like cops can kind of charge people whenever the fuck they feel like it. But if like somebody does something to me, I once heard a senator, Kentucky senator, had actually told me that you could get a warrant for somebody who threatens your life. If somebody who threatens to injure you or threaten your life, you could get a warrant out on them just based on you saying they said that they was going to injure you. And so that's one thing which I didn't know, but how does one go about getting that charge out? And how does a person even put a charge on someone else? You know somebody stole some shit on you and you want to press charges. How the fuck do you do that? If you cannot get the cop to believe you, and if the cop doesn't, give their fucking cop kingly fucking privileges out to others, because they could just randomly beat up anybody that they feel like it, right? And just put on charges on them and say they did this, and then we just have to live with it. The cops can beat up whoever the fuck they want to do. It's all for law and order. Who gives a shit? Nobody gives a shit about anybody else, right? You're driving on the interstate, you see some asshole getting ran over or being pulled over on the side of the road. You don't stop and say, hey officer, why are you fucking with my fellow American? You say, damn, that fucking antelope got it. God damn, that cheetah fucking devoured that poor sickly antelope. I'm glad I'm a fucking, a stallion, and I'm just running along with the rest of the pack, and I didn't get fucking hit. But it's only a matter of time. It's only a matter of time. You let these fucking wolves around here, they're eventually going to get you. So that's that's the voter rejected Constitution of 1966. That's Section 4 says that it gives the people the right to alter, reform, or abolish the government in such a manner as they may deem proper if they don't get their peace, safety, happiness, and freedom and protection of property. Section 14 of the Bill of Rights states that all courts shall be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law and right and justice administered without sale, denial, or delay. Which, that is what I was talking about, Section 14. So Section 14 says something happens to me, I can file a charge, and then that's supposed to put in, forth into some sort of process, an investigation, somebody asking questions, and perhaps a trial, because there is an allegation against somebody else. They have a right to face their accuser. So if I say that person did me wrong, then I'll go into the court and say that person did me wrong, and here's my evidence, and here's why I think they did it, and that's it. And frankly, I think that should be plenty enough for, you know, a society, a good society. You know, what do you do when you have a group of people? One person says that person injured me. Well, you have to have a process, and you have to have a fair process that actually goes through. You know, for anybody that puts up a complaint against somebody else, it should be looked at thoroughly. Somebody should be paying attention to every complaint every citizen has out there. 911, yeah, when there's a murder, when someone's getting shot, that's when you care. But preventive medicine is cheaper than emergency medicine. So if you can start solving the problems before it gets to be 911 level type of problems, maybe the police could just, you know, help others and just give a shit about other people. The police are out of control. And, you know, John Price was murdered right here. They say it was a suicide, but really, do you believe that? John R. Price. And right here, 710 South Main Street. It's like right there. It's like go 2 blocks, 4 blocks, 2 blocks, bam, on Main Street. Right there on Main Street. This is kind of a bedroom. It's sort of a town off to the side of a sort of, not even an interstate, so sort of a main big road, you know, Dixie Highway. It's on the way to Louisville, on the way to Elizabethtown and some of the other big cities, Fort Knox. And so it's sort of a bedroom community off to the side. And so the fact that it's happening in bedroom in pockets, you know, we're having like little pockets that should be protected from the militarism. But I digress. Okay, so section 14 states that all courts shall be open in every person for an injury done him or her in his or her lands, goods, person, or reputation. So if somebody takes your land, takes dirt off your ground, takes some goods, steals your stuff, hurts your person, assaults you, does something to your reputation, you shall have remedy by due course of law and right and justice administered without sale, denial, or delay. So you should have the right and justice administered. You should have some type of justice administered if there was something that was wronged you. So investigation, ask the questions, put them in front of the judge. What happened? Here's what happens. If you get to be, you know, filing lots of fucking little shit all the time, then maybe they can say fuck off. But, you know, until you get to have that sort of frivolous reputation, the reputation for just being frivolous about little shit, then, you know, then it doesn't fucking matter. You know, it all starts with that initial complaint. And everybody should have that right to a complaint, and then the process should push that complaint sort of in a very conform or you know, the very same process over and over again. So it should be consistent. It should be a consistent process. The Kentucky Supreme Court ruled that this section 14, that says all courts should be open and every person for an injury done to him and his lands, goods, person, or reputation should have remedy by due course of law and right and justice administered without sale, denial, or delay. Combine this section with section 54, which is first found in the current Constitution, which states the General Assembly shall have no power to limit the amount to be recovered for injuries resulting in death or for injuries to person or property. So they cannot say, they cannot limit the amount to be recovered. You can't say you can only get $1 million and that's it, because you never know how much injury could be done to somebody. And also, yeah, how much, you know, a big ass company like McDonald's, they wouldn't give a shit if they burned just one motherfucker with coffee. Pay her off, who gives a shit? But to punish the company, they needed to have punitive damages. Supreme Court has ruled that this section, together with section 54, first found in the current Constitution, which states that the General Assembly shall have no power to limit the amount to be recovered for injuries resulting in death or for injuries to person or property, and section 241, also first found in the current Constitution, which enlarges the right to sue for wrongful death. So you can't limit the amount that you get recovered for injuries resulting in death. That's section 54. And every person has a process that they can go through if they've been injured. So everybody's got to go through a process. If you've been injured, everybody has a right to have no limits to what they can go after. And then after section 254, enlarges the right to sue for wrongful death, serves as a barrier to statutory tort reform, and substantially enhances the rights of those who are suing to recover damages for personal injury or wrongful death by prohibiting the legislature from abolishing or diminishing rights to sue that existed before the adoption of the current Constitution. So that's it. That's fascinating. Section 14 says everybody's got a right to put a complaint in, and then for the cops to go after those people. Section 54 says that every Kentuckian has a right to sue for as much as they want to sue for. There is no limit for the damages you can seek from someone else. And then Section 241 says that it enlarges the right to sue for wrongful death. So, you can't, not sue somebody for wrongful death. Well, actually, we'll take a look at that one when, Kentucky Constitution 23 comes up.